Good evening, everybody, and welcome to this program. It's my pleasure to introduce the speakers this evening. They are both eminent experts in the fields and need no introduction to those who have heard them before in Moneylife Foundation event. Mr. Pranay Vakil, one of the most respected names in the real estate industry. Mr. Vakil has over 18 years of experience in providing consulting services in the real estate market. He is the former chairman of Knight Frank in India, and since 2012 October, after he left Knight Frank, he heads a consulting company called Praron Consulting. Mr. Vakil is a concerned citizen and is active in voicing his views to the government and legislative authorities to spearhead legal changes relating to the realty. He is the co-chairman real estate of FICCI and member of Urban Development Committee of CII. May I now request Mr. Vakil to please make his presentation.
Very good evening to you, and when all of this being said, let's get started with a question. What do you think is the biggest problem of any developer today? Any developer. What do you think is the biggest problem? That's an opportunity. That's not a problem. Permissions, yes. Money, yes. Because what I want to do is try and see whether this bill is going to address all the problems that we are talking about, right? So that's the developer's problem. What do you think is the buyer's main problem? One single problem. Being cheated, right? So that's the problem of the buyer. What's the problem of a lender? He's lent a lot of money to the developer. He keeps on getting all the promises that it will be over on a particular day, and it doesn't get over. And these are all close-ended funds. There's a 5-year life to the fund. So if it doesn't get over, there's a desperation. And in the desperation, you offload at a discount, right? So that's what is happening to the lender. What do you think is the problem of the government? You said it, right? I mean, it's off, on, go, no-go situation, which is happening so often that this particular bill has been debated now for over 3.5 years, 4 years. I have personally seen 4 drafts until you get tired of looking at the same bill over and over and over again. And when Suchita invited me to come and speak to you, the first thing I tried to do is to grab a copy of the bill. 2013, the cabinet has considered this bill, right? So I said, look, let me at least see what are the differences between what I saw last, which was in 2012. I happened to represent to the government on behalf of FICCI, so therefore I had a copy in 2012. All of what I'm going to talk to you is on the basis of 2012 bill, because 2013 bill, I believe we are not able to find. Well, that's the state of affairs. That's where the government is. But I do believe and I feel that there are very few changes between 12 and 13. So therefore, I mean, we will not be completely out of line. There might be a few words here and there that might be relevant. Before we really get started on the bill, I would like to ask another question, sir, to you. What are your expectations from this bill?
The object is to bring transparency in the real estate transaction and to have some adjudicating authority, that real tribunal. So these are the two very laudable objects, but whether these objects will increase transparency or will create corruption, further corruption, I think this is, to my mind, is the biggest, could be a biggest hurdle. If we go only through the objects, really laudable. But real implementation, we have seen, can Urban Land Ceiling Act came with so many laudable objects, and it miserably failed. So here also I have my own doubts.
Absolutely. But you hit the nail on the head by saying that the expectation is that it will bring transparency. The expectation is that it will give you a good judicial process to resolve your problems, right? So, what I want to do is to go through the provisions of the bill to see if these expectations are met. Because what's life? Life is about managing expectations. As long as the government is able to manage the expectations of the people, all the stakeholders, the bill will be a success. But if it does not, and at the end of the talk, let us kind of determine whether it is or it is not meeting the expectations of people in this room. Right? Is that the right way of going about it? Okay. What does the bill seek to accomplish? Transparency, as Mr. Ramani said, and very, very true. What I've tried to do is to give you the measures that have been implemented for transparency and what are the implications of those measures. The next thing we'll deal with is to protect the consumer interests. What are the measures? And the gentleman there said that the consumer needs to be protected. What are the measures and will it really achieve what it set out to do? The third is the dispute mechanism. We'll spend minimum time on it. Last, what does the bill attempt to do is to provide a guideline, a model to the states. Now, why is that important? That's important because real estate is a state subject. The center, and we'll of course seek the opinion of the expert on this, but the center can only make recommendations, cannot really prescribe a law on real estate for the states. So what will the states do? The states will have to mirror that law for it to be effective. Has this happened in the past? Let me give you a small story about the example which you gave. Urban Land Ceiling Act. 1999, the central government decided to abolish the Urban Land Ceiling Act. The states slowly started implementing. It took them over 10 years to implement a law for abolition of Urban Land Ceiling Act. And there are 2 states that have still not passed those laws. So that's the state of affairs, because there is no time limit prescribed for the states to pass that law. So, what are we doing today? We are discussing something which may or may not happen or happen at a later state as far as the all of India is concerned. For Maharashtra, it might be a little different, and we'll deal with this separately. So, let's start with transparency. What are the measures taken for transparency? Sir, are you able to see it? Yeah. There is an authority which is created where any developer wishing to develop will have to register that project with that authority. And for that purpose, he'll have to make all kinds of disclosures. These disclosures would be: where is he developing, what are his titles, what is the plot area, what is going to be the size of the apartment. It has reference to everything except FSI. That is very surprising. It talks about the carpet area, it talks about the built-up area. There is no reference in the entire bill to FSI, which is the most important thing. Like, the government goes on to say that the registration process will not apply for lands which are below, say, 1,000 meters in size, say 10,000 feet in size. Now, all of us who are connected with real estate know that the land is not as important as the FSI that it justifies. Because on the same 10,000 square feet of land, you can either have a development of 15,000 feet or 50,000 feet, depending upon what you're doing there. You're doing something for MADA with 4.5 4 FSI, right? You could go up to 40, 50,000 feet. And then you can sell it at something completely different, which is like 75,000 feet. Let me give you one example. Most of you must have been to Altamount Road, right? Next to the Prithvi apartment, there's a building that's coming up. If you see the footprint of that building, it's only 20,000 feet of land area. How much is the construction? Over 3 lakh square feet. How does that happen? Who's permitted that to happen? You know why it is 3 lakh square feet? Because each flat is supposed to have a post box room, a room in which the post box is kept, of 360 square feet. Post box room. Alright, this is how a 20,000 square feet land can convert itself into a 3 lakh square feet development. So, the driver should not be the size of the land alone, but to my mind, what is the total development that's going to come up on that? If that development is going to be in excess of a certain square footage, then obviously it should fall within the ambit of the law and the bill. But if it does not, then it could be exempt. They've also said that if you are building only 12 flats, you don't have to register yourself. But in the same breath, they've also said, if it is in phases, then this will apply to each of the phase. So if somebody has a large land area and has 10 buildings, all of 12 flats each, and he tells the public that this is phase 1, 2, 3, 4, 10, etc., does he get outside the ambit of the law? I'd like to refer it to the experts sometime. But so there are those kind of anomalies, there are those kind of issues which will keep coming up. The law will have to be debugged during its implementation stage. Let me give you another example. The way this bill is worded, and if it becomes a law, and it has possibly become a law, 300 million square feet of development will require registration. Are we geared to handle that? Do we have a mechanism, all states put together, to register 30 crore square feet of development? Now, so if you don't register, somebody will be in default. And if that fellow is in default, all kinds of things can happen to him. In the extreme case, even imprisonment, which I'm sure Parimal Bhai will throw light on. But may or may not happen. But my view is that initially, at least for the next 1 year, whilst the law is being debugged, you will have to be careful. Otherwise, including the big company like the Mahindras and Tatas and all of them will be in default. Why? No reason except that the government is unable to cope with this kind of registration. So, on transparency front, you have to go out and register, and I will have a separate slide on what are the requirements for registration. I'll deal with it in a minute. Now, you're not supposed to advertise, which most people were doing. They were spending more time creating a nice looking brochure than they were spending on the architect to get the plans done. Why? Because they felt that if you make a nice shiny brochure, you'll be able to sell it, whether you have approvals or not, or whether you have even acquired the land fully or not. It might be an agricultural land which you still have to convert, but you still come up with a brochure, you collect the money. So these kind of malpractices were happening. To stop that, the bill says You can advertise only if you've got a commencement certificate. You've registered with this authority. The authority has given you a login ID and a password. You put everything onto the website. Then you can begin to take money, and that also within limits. You can't take more than 10% without signing an agreement. We'll come to that in a minute, because the state law says 20%, the center says 10%. What will prevail, God alone knows. So, like I mentioned to you, registration requires a lot of disclosure, and there are going to be rules to be made by the government which will tell you what is to be done, what is not to be done, how much to be disclosed, and all of that. There's only one thing which I'm very, very particular about. If someday the law says that disclose the name of the buyers, it's going to be a major problem, because that list can soon travel to Dubai, and somebody can get after you because these are expensive flats. And if there are a number of societies today that do not put the names of the owners, and they've done away with the habit of putting up the names of the owner because it can be misused. It can go in the wrong hands. So, my appeal to the government is that please do not insist that the names of the buyers are put on the website, otherwise there will be a major problem. Yes, you can say that we were doing 150 flats, out of which 50 are sold, that's fine. But who are the buyers should not be disclosed, is my view. For the first time, and sir, the lawyers are not going to be very happy about this, but for the first time, there is going to be a standardization of the sale agreement, and the format of the sale agreement, the pro forma of the sale agreement is supposed to be put on the website. A person will know what he's going to sign, which is excellent. And this is going to be standard across the country. So instead of going to a lawyer and making out an agreement for every sale, or accepting an agreement which is completely one-sided in favor of the developer, at least you have an authority which is giving you the right agreement, a balanced agreement, which will serve and protect both the developer and the buyer. So I think that's a good sign. What are the implications? Very simple. If you're a buyer, sir, and you've seen 10 apartments, and you want to compare these 10 apartments, are you able to do it today? You're not able to do it. You know why? Because the loading is different from different developers. One fellow would load 30%, the other 40%. One fellow's price will include this, the other fellow says, I give you a warm shell, bare shell. You can't just compare. With this registration that is taking place, you will be able to compare apple to apple. If you have seen those 10 projects, you'll be able to say, yes, this is the exact square footage I'm getting. This is the price I'm paying. These are the amenities I'm going to get. When I'm going to get. And that when is very important, and I'll just digress for 2 minutes. Sir, you have an option today of buying 2 apartments. One which is ready and one which is under construction. And you find that the under construction is cheaper by 10%. So you fall for it. To save that 10% on a high value transaction is a lot of money. At the end of it, if and when you get that flat, with a 2-year delay at least, the rate per square feet that you will effectively pay will be much more than what you would have paid for a ready construction. And this study we have done over and over again, And we found that people ultimately pay about 25% more when they do something under construction. Why? Because for all you know, in the next 8-10 months, you will soon come to 80% because everything is linked to construction progress. Not how much of construction, but how many floors are added. And some of you are connected with property know that creating an edifice in the construction cost you less than 30-35%. The balance 65% is the money that you spend in putting up the lift, the interiors, the electrical works and the water and all of that. So finishing the flat is the major expense. But all collection by the developer is linked to how many floors you put up. So you would have paid 80-85% of the money in the next 8 months after booking, but you are waiting for 3-4 years to get your flat. And you can't even deploy that flat on rent because it's not there. It's under construction. Whereas had you bought it, you could at least deploy it, and that I'm not even counting. So, coming back to the disclosures, coming back to the implication, comparison, apple to apple, between various developments that you are considering, and I do feel that a balanced agreement will do a lot of good to all the buyers that are looking at flats, because everything will be interpreted properly, debated, will possibly be debated also in the courts of law, so all interpretations are then available to you. So that's on transparency. Consumer protection. Sir, you mentioned about consumer protection, and let's see what the bill is going to do. What's happening today? Once you book your flat, you don't know what's happening to your money. So from time to time, you pay this money to the developer, and it goes in what direction we don't know. It may not go for the project. It could be diverted for buying some other plot of land or repaying some old debts, all kinds of things. Today, according to this new bill, it will have to go into a separate bank account, and there is an arrangement which is closest to escrow by which that money can be used for the project and nothing else. Now, if somebody is doing a very large project and it's in phases, what needs to be interpreted is that does it apply to every phase? So that for every phase you collect the 70% and use only for constructing that building, or can you use it for the compound wall or common amenities and stuff like that? So what is a project? Does it mean a phase or the entire project is something which needs to be understood? From the buyer's point of view, he's got only 2 worries, sometimes 3. His major worry is, will the project be completed? His second worry is, will the prices go down after I bought it? And his third worry is, will the interest go down after I bought it? Because if I borrowed money, and if this interest rates keeps on going down, then he will look like a monkey. So, there are occasions when there may have to be cancellation. And this bill provides for a mechanism by which if there is a cancellation, why? Because the developer hasn't done what he's supposed to do. You get your money back with interest. They haven't prescribed the interest. They have said it will be prescribed by the law in due course. But at least they have said there will be an interest when it comes back to you. So that's a protection. There is also a provision for delays. If there is a delay in construction, in delivery, there could be an interest or a penalty on the developer, and therefore, that instance which I gave you, the example which I gave you of 2 and 3 year delay, can somewhat be countered by this. There is also a provision that if there are any structural defects for up to 2 years from the time you take possession, the developer is supposed to fix it free of charge, free of cost. I've read some advertisements from certain developers in Pune who said, we will fix all the problems that may arise for the next 2 years. All that he is doing is reflecting these provisions. So what he is doing voluntarily will become compulsory, for him to do as the time goes by and the bill is implemented. The good developers even today have some kind of a warranty, and they are kind of fixing these problems. It's only the fly-by-night operators, who kind of say that here's the flat and then don't ask me any questions. He may not even be on the site to answer questions. Real estate agent, and this is very close to my heart, being an agent myself. There's going to be a registration of the real estate agent. Again, what is not clear is it going to be a registration for a particular project, or is it going to be a generalized registration? Because in one of the things that the developer is supposed to disclose on the website, is supposed to give the name of the agent. So I'm led to believe, sir, that this is specific to a project, which means every time you change a real estate agent, you will have to again approach the authority and kind of carry out those changes on the website. We've also heard of cases where things get stuck. Some of you know the story about Mont Blanc, right? Which is at Camps Corner. How many years was it stuck? And who completed it? Not the developer. But all the people who had bought flats in it got together, put the money, completed it, and occupied it. This is something, again, the bill incorporates, that if the developer does not complete, the competent authority can take charge, complete or form an association of the buyers to kind of complete this. Again, a protection for the buyer, and I think it's a good thing. What are the implications? Strict control on utilization of funds. There won't be any diversion of funds, which is excellent, because this, according to me, is 50% of the problem today, why some of the things get delayed. Greater accountability by developer for representation that he is making. He will not be rash in doing it. He'll be very careful about what he says, because he can be hauled up. And I think a regulation of the real estate agent, again, is something which is good, desired, awaited for a long time, because the real estate trade now is getting very, very organized, but the agents are not necessarily getting organized. I mean, you'll find that every street corner, there'll be some board saying real estate consultant. Everyone wants to call himself a consultant. But if you go and ask him, he's doing it because he's fit to do nothing else, and therefore he's put up a board. And he thinks that information is equivalent to money, and therefore that's how the agents kind of come up. Not all of them. There are a number of good agents who really care for their clients. They understand the client's need, and for them, the transaction is not as important as the client. Whereas for some of the others, the transaction is very important, the clients are not. So he somehow tries to fit the transaction. So that's on the protection. Sure.
Here, implication, strict control of utilization of funds, 70%. I'm just hypothetically taking a case of Malabar Hill. Some builder has purchased a land for 60,000 rupees FSI, or 60,000 per square foot cost is there. And his construction cost cannot exceed more than 5,000 rupees. He's selling it for 70,000 or 80,000. How can you deposit 70% of that in the fund? I think this is a work.
Well, let me tell you how that 70-30 has been worked out. I mean, it's gone back and forth from 80-20 to 75 to 70, but the assumption is that the 30% is the profit he is expected to make, and if he keeps the profit to himself, that is fine, but the balance 70% at least should be used for the purpose. Coming to land, let me tell you the complication. You put one complication before me, I'm putting one complication before you. If it's a joint venture with the landowner, where the developer is not paid for the land, sir, how are you going to compute 70%? That again, I mean, a lot of these questions remain unanswered. And if he's free to spend the balance amount and 70% of that, I think he's going to be very happy if the land part is not. But in the definition of a project, they've included land cost. So, if the land is not paid for, do you take notional cost? I'm not sure. There is no discussion on that in the bill.
Secondly, here, the project will be completed by competent authority. Under the Central Act, competent authority is not the one which is in the MOFA. It's a municipal corporation is a competent authority. CITCO is a competent authority, but municipal one who sanctions the plan. Oh, I don't think the BMC can complete any project. Not workable, if that is correct.
I think in practice what's going to happen is that they will get all the buyers together, you know. Well, all that I'm saying is at least they've made a provision for it. The good thing is, Mr. Ramani, that they've made a provision for it. That if it gets stuck, what do you do? And, I mean, these authorities have been given the power of a civil court, which Parimal Bhai will confirm, so that there is no appeal against what this appellate authority does. And that, again, is something which is very important. Okay, I very quickly go to a listing. It's a very straightforward listing of what the promoter is supposed to do. Who is a promoter? The way we understand a developer is the way they've defined a promoter. This is not a definition from the Act. If I was to take the definition, it will take up the full page. So I've just summarized it. I mean, it is something that all of us understand as a developer, but unfortunately, in this definition of a promoter, and I'll show you how it can hurt. Even a buyer who is purchasing in bulk for resale is a promoter. Can you see the problem? He's not the guy who's paid for land. He's not the guy who's responsible for engaging those contractors. But all that he has done is he's done a bulk purchase. Now, sir, to digress for one moment, let me tell you that I'm connected with a real estate fund where we have done bulk purchase. Right now, the developers don't have money. They don't want to bring down the price. So you have to come up with a face-saving formula. So what is that formula? We tell the developer, we're buying 100 flats. So he is able to bring down the price substantially without affecting his retail market, because he doesn't have to then explain to anybody why on a 100 flat sale he's giving a lesser value. So it's good for him. What do? We put that money into escrow to be used only to create those 100 flats. So we are also secured, right? And the developer benefits because there's a lot of activity on the site and he's able to get a lot more bookings because everybody knows that there is something happening at the site. But I will have to be very careful henceforth in doing this bulk purchase if I am going to be clubbed with the definition of a promoter. Because the promoter has huge amount of responsibilities under the bill. He's the developer. So a bulk buyer is put on par with the developer, and that is going to cause a lot of problem, I feel. So that's on the definition part, but what is it supposed to do? Is supposed to create that web page, load all the details, from time to time change those details, provide quarterly updates of what's happening. on his project, on his apartment, what is going to be the carpet area, all of that. He can now release an advertisement once he has kind of put it on the website, but he will have to give reference to the website. The advertisement compulsorily must refer to the website, so there's a cross linkage somewhere available. And unlike today, he is obligated to provide to the buyer all the information, including the FSI usage and all of that. So I think that is a good thing. All the approved plans a buyer can ask for and get it. Now, you know that there are developers who kind of complete the building, give you a possession, and don't worry about either a completion certificate or the occupation certificate. Under this bill, it is obligatory on the part of the promoter to get you the completion certificate. So that's very important. Now, many a times we've also seen the fly-by-night operators. What they do is they complete the building, hand it over to people and disappear. But until the time the society is formed, under the bill, he's supposed to even manage that. Make sure that the electricity, water and all that is kind of... These are all very, very mundane, but they're all listed out there. He's not supposed to accept advance in excess of 10% without the agreement, something which we referred to earlier. Rectifying structural defect is again his responsibility. And executing a conveyance deed in favor of the buyer is something very important. So he's supposed to execute that, register it, and that obligation has been put on him as much as the buyer. And of course, hand over physical possession, debug the thing and maintain it for 2 years. Now, it's not one-sided alone protecting the buyer. They've also dealt with how to protect the promoter vis-a-vis the allottee. Now, that's a new word that's been used. What we understand as a buyer, the bill calls allottee. And so the definition of allottee is what you and I understand as a buyer of a flat. But they've tried to include 2 more persons in the allottee definition. Somebody who gets a flat, say as a gift, under some kind of a transfer, may not be for consideration. He is also an allottee. And this is going to cause a lot of controversy, sir. A subsequent buyer of the flat is also an allottee. So, if the developer sells to A, during construction A sells to B, B sells to C, the A and B in between also are responsible. And therefore, I think this definition becomes very relevant. Obviously, the allottee is entitled to full information and he is supposed to get everything that he's supposed to get as a buyer. I'm not going into the details. He's entitled to possession as promised by the developer. If not, he's entitled to some compensation. Well, he can claim refund compensation for delays. He is entitled to ask the developer for everything and anything which affects his title. So to get his title, whatever back agreements are needed, he's supposed to kind of get. But then there are some responsibilities. The allottee is supposed to pay the developer or the promoter in this case whatever he has promised to do according to the time schedule that he has agreed to. He's supposed to pay the registration charges, the stamp duty as agreed in the original agreement, and also interest for late payment if there was a late payment. There is also some kind of an obligation put on the allottee to form a society. Some of you must be aware of certain changes which are taking place in the Societies Act, where there's a classification into active members and non-active members. You are supposed to attend the AGM. If for 5 years in a row you don't attend the AGM, you could be disqualified. And there are certain sections in that which say that you can even lose possession of your flat if you remain inactive for 5 years. This is something which I would request Parimal Bhai to throw light on. It's not concerning this directly but indirectly, but it's very important to my mind. Dispute resolution, I don't think I'll take a lot of time on this, but for all practical purpose, it will operate like a civil court. There is a appellate tribunal, so you can appeal against it. There is time limits prescribed for everything. Even when you apply for registration, the government is supposed to come back to you in 15 days' time. What's going to happen is on the 14th day, you're going to get a letter asking you to submit a lot of details so that the 15-day deadline, is kind of bypassed by the government. This is very mundane. I mean, it is there. It's very well defined. I would not spend more time on it only because, yes, it will reduce delay instead of waiting for 10 and 15 years. This resolution can come in maybe 6 months, which is a good thing. There are punitive charges. They've said that 10% of the construction cost can be the damages which can be charged to the developer, which is a great thing. For few other things, it's 5%, but the maximum 10% is something which the developer will have to fork out if he does not do what he's supposed to do under the bill. In some extreme cases and repeat offenses, it could even be imprisonment up to 3 years. I do hope the Maharashtra government has not passed, at least incorporated these kind of things in their law by which there is imprisonment. There's only financial penalty. But the Central Act talks about it. Very quickly, if you do want to apply for registration, what is it that as a developer you are supposed to give? Now, this is important because a lot of developers I know start a new company for every project that he is doing. How do you deal with that situation? How do you go into the track record of a developer, even if he has given you full information? If for every project there's a new company, and even listed big companies do this because they can then hive off to a fund or something like that, and it becomes very, very convenient for them to do. So, disclosing details of the developer, its entity, prices, all of that is important. But what happens if there are multiple entities? How do you track them? Is something which needs to be understood. Commencement certificate is different from completion certificate. Commencement certificate only means that you can commence work, but the details have to be given for registration according to the Central Act, according to the State Act. If you got your occupation certificate, you are exempt. We'll come to that in a moment. Layout plans, amenities, swimming pool, etc., etc. All of that has to be disclosed and uploaded onto the website, something which is transparent to the world. If you're a buyer, you can visit the website and get all the details. Carpet area. Now this is important, but when the ready reckoner deals with rates which are on built-up area, how are you going to kind of regulate carpet area is something which I would look to you, sir, on. Format of the agreement we talked about and the agent's detail. If you give all of this, then within 15 days the government can register the project. Well, these are a few other things which are part of the disclosure. details of the contractor, architect, structural engineer, everything else. I don't know why the law has not clubbed the real estate agent with all of these. There is one clause which only deals with this, a separate clause which deals with real estate agent. But that's the way it is. And there is an affidavit, which is also kind of uploaded on the website, which will talk about the titles. Whether he has a clear title, is it a joint venture with the landowner, what is it? All of that has to be disclosed. Encumbrances, if any. Time to completion. He's also in that affidavit making a statement that 70% of the amount collected by him is going in a separate bank account and all that. And they've kept the window open to say that such other details that may be prescribed, that there are going to be more details which are going to be prescribed. Okay. We talked about what the bill has covered. The transparency, the dispute mechanism, protection of the buyer. What does it not cover? What does the bill not cover? To my mind, the bill is completely biased towards housing, as if to imply that there are no chori in commercial development, malls and all that. There is a reference to commercial development indirectly, but the way that apartment has been defined all through, the sense that somebody gets is that this is a bill which only addresses housing and doesn't address any of the other things, any other development. There is no reference to ready reckoner. It doesn't suit them because of the carpet area and built-up area concept. To my mind, one very important thing, and the gentleman here mentioned it, it does not deal with the problem of black money, the menace which is there in the real estate industry. This is very important. I cannot overemphasize this. But they have defined a person in default, but they haven't included in that definition somebody who accepts a consideration otherwise than through a check. It is so plain and simple. Why is this act needed, sir? You talked about black money, right? Why is it not covered? Why are they silent on something as important as this? Is it not an issue? Maybe it's not an issue in Delhi, but it's an issue elsewhere. But it's something that needs to be addressed. We're going to take it up very, very seriously through IMC, through FICCI, that look, you have to take this opportunity to take a holistic approach and not only look at other problems, but also the black money problem. There will be conflict within the state law and the central law. We'll talk about it, and there are experts here who can talk about it. But yes, there is going to be a conflict, because I will throw open for discussion at least 4 such conflicts which I see between the state law and the central law. There should be, like I told you earlier, a provision for debugging this as we go along. So there has to be a small trial period, to my mind, because the first time we are exposing ourselves to some legislation like this. And don't be very harsh in giving penalties until the time the law stabilizes, is my feeling. Blacklisting of developers. So we talked about a new entity for every project. When one entity runs into a problem, the developer today starts focusing on other entities and keeps it on the side. Will this bill, will this law address that? I don't think so. I don't see any provision in the law which will take care of multiple agencies, not only for the developer, but also for the real estate agent. He may have multiple agencies. He'll register one, he may not register other. Today also he's doing it. He has got 3-4 names under which he operates. There is no reference to rating of developers. Why should the law not compel that all developers should be rated by certain approved agencies, and that rating is disclosed in the advertisement, in the website, and everywhere? I feel it will do us a lot good. So what I'm going to do now is, I'm confused. I have a lot of issues which I don't understand. And I'm going to look to you, sir, to resolve this, to opine on this, because when you don't even get a copy of the bill, all that you can do is raise issues, raise questions, but not possibly have the answers. To my mind, there are a few issues that are important. State versus center, what will prevail? In my limited understanding, the state can make a law stricter than what the central government has prescribed. But if it says that you can take 20% of the money upfront without the agreement, when the Central Act is saying 10%, is it legal? I don't know. I'll seek opinion of all of you. How are we going to cope with the registration of 300 billion square feet that we talked about earlier? Developer with multiple phases and companies. What is the legal solution to that? Because you have a partner in every entity that we're talking about, a different partner. A landowner may be a partner, a financier may be a partner, etc. How are we going to control the real estate agents? Is again a legal issue when he's operating under so many names. So one other thing which I'd like to bring up, there's a huge amount of database which is going to be created arising out of this registration. Can we fall back on that database as a precedent? Because it's a government database, it's a government website. There's so much information on it. If we can fall back on this database which is created for the 300 billion square feet, I think it will be an excellent thing. But it has to be legally binding when you fall back on the database. That's what I'd like to know. There are a few definitions which are very peculiar in the law. I talked about the allottee, where the subsequent buyer is sought to be included. We talked about the promoter, where the bulk buyer is supposed to be included. The project, where you have phases, and how do you kind of interpret that? Now, some of these also require to be dealt with. 2 more minutes on what the Maharashtra government has done. How many of you have seen the statement of Sachin Ahir after the bill was passed by the cabinet? He's actually gone to the extent of saying, I don't agree with this. Right? He says this is our prerogative, the state's prerogative to do. So please clarify the central government. Is this binding on me or not? It came in Hindustan Times. I'm sure some of you must have seen that. But this is where, and this bill was passed by both the houses in Maharashtra on 12th of July 2012, much prior to the central government cabinet even kind of taking it up. But Maharashtra is the only one. There are other states who have to still do it. I happened to be very briefly with Narendra Modi, and this was a question put to him also. And he says, yes, we will do it. But Maharashtra has taken a lead on this, and which is very important. Well, very good question. Both the houses have passed this, but it is awaiting the assent of the governor, which is equivalent to the assent of the president. You can sit on the edge of this. And I've said that this law is going to replace MOFA. MOFA is something which everyone has understood now. They're operating. It's been fully deciphered. The number of case laws on the subject, that will be put aside, and this new law will take over from MOFA, is what the Maharashtra government is saying. Although most of the provisions are in line with the Central Act, there are a few things which I'm pointing out here where there is a conflict or a disparity. Why? Because the Maharashtra made the law even prior to the cabinet kind of taking it up. For example, in Maharashtra, if you want to alter the plan, unless the buyer says yes, you cannot alter the plan, something which is missing in central law. Or for that matter, the penalty provisions in the state government law are far softer than in the central government. Like I mentioned earlier, in state, Maharashtra state, you can accept 20% without an agreement. The center says 10%. So these are some of the things which I've tried to bring out. Having said this, let me summarize. Let me conclude by saying it's a step in the right direction. Unless we really start to make a law, unless kind of we make a few mistakes as we do that, how are we going to correct ourselves? So, there is that debugging process which will have to happen over a 6-month to a 1-year period, but it will provide protection to the buyer. To some extent, it will also provide protection to the promoter. And if you are at all hearing complaints about this bill, it's not coming from organized sector. The organized people are saying, this is what we've been doing, and this is what you're asking us to do. It's only the unorganized, fly-by-night, the one project developers who are kind of complaining that, look, this is not the right thing to do. So with that, I'd like to hand over.
Lovely. Thank you, Mr. Vakil, for such an excellent and detailed presentation.